Although,
Yes, thank you. Okay, so before starting our topic for discussion today, let me emphasize why we have chosen this topic, that is arbitral tribunal independence and impartiality. There is no specific requirement for the appointment of arbitral tribunal, even though we have to make sure that the arbitral tribunal is very much independent and impartial. That is, he gives equal opportunities to the parties and none of his activities is being biased by either of the party. So this kind of qualification is very much essential because if the parties find that the award passed by the arbitral tribunal is being influenced by other party, then the party could raise this ground before the court to set aside the arbitral award. So if you are being appointed as arbitral tribunal, make sure that you are not either influenced, and you give equal opportunities to both the parties to present their case. Okay, so we have been seeing this, what is arbitration and how it is happening, and the appointment of arbitrator. Even though, let me explain it in two lines. As you know, arbitration, it is a private proceeding wherein the parties choose the arbitrator to resolve their disputes. So, unlike court proceedings, unlike judgment in a court, the proceedings are very much flexible and it can be decided by the parties by discussing with the arbitrator. And of course, the arbitration proceeding is entirely confidential. That is, the arbitral award, which is passed by the tribunal, it could not be published before any of the forum. But if it is a court judgment, you can see it in many public forums. But the arbitral award, it is not possible yet since it is a confidential proceeding. So, what is arbitrators' independence and impartiality? It is one of the core component wherein the arbitrator will make the decision. That is, he will pass the award solely based on the evidence and arguments submitted, and without having any external pressures and bias. So, the arbitrator's decision should be purely based on the documents and the arguments presented by the parties, and he should not get influenced by either of the parties' actions. And he should, with the activities of the parties, that is independence and impartiality, he should make sure that all the parties have confidence in his proceedings, and he should maintain the fairness and the integrity of the arbitration process. So let us see what is independence and impartiality separately. Uh, the independence refers to the absence of the parties' relationship with the arbitrator. In the day one session, we had discussed that the arbitrator should not have a relationship uh, with either of the parties, dispute in hand, also with the outcome of the dispute. So the arbitrator, before his appointment, that is whenever he's been selected, he should disclose whatever the relationship that was maybe existing between the parties. If not, he can say it as no. So he has to disclose the independence with the following topics, that is financial independence, professional independence, and personal independence. He has to make sure that there is no past financial interest or stakes in the outcome of the arbitration as well as for the current dispute. And there is no past or current professional relationship with either of the parties. Also, he should make sure that he does not have any close personal relationship that may affect the arbitrator's objectivity. Let me explain this with an example. Imagine that there is an arbitrator who has a financial interest in one of the companies involved in the arbitration. So consider that the arbitrator owns a share in the company. So there is a risk that his decision could be influenced by the potential impact on their personal finances. So these kind of financial relationship with the parties, this may give a doubt regarding the arbitrator's independence. So make sure that if you're being appointed as arbitrator, you does not have any financial interest either with the company, also with the outcome of the dispute. Next is arbitrator's impartiality. uh, we have been saying this time and again. The arbitrator, he has to give fair and equal opportunities to both the parties. So we should not bias or get influenced and give more opportunity to one party and not giving sufficient opportunity to another party. So the arbitration award passed under that kind of circumstances, that could be challenged before the court. So arbitrators' impartiality, key aspects. So let us see what are the key aspects in that. Lack of bias. So the arbitrator's decision should not in a way that it favors one of the parties. It should be completely based on the documents and the representation made by the parties during the proceedings. And there should be equal opportunity given to both the parties. Of course, the decision made by the party should be based on the merits of the documents submitted, and he should be neutral in making his decision. So let me explain this with an example. Consider that an arbitrator has publicly uh, has publicly expressed strong opinion about a particular legal issue central to the dispute. So in that scenario, even the arbitrator has no direct relationship with the parties. His preconceived stance on the issue might cause one party to get disadvantaged, questioning his arbitrator's impartiality. So let us see what is the legal frameworks and standards say on this arbitrator's impartiality and independence. Of course, the ancestral model law speaks on this emphasis on the arbitrator's impartiality and independence, and it has provided a framework for ensuring arbitrators' impartiality. Before the appointment, the arbitrator has to submit before the appointment, the arbitrator has to submit a disclosure letter stating that is past and current relationship with either of the party, as well as the dispute uh, for adjudication and the outcome, that is award of the dispute. So once this disclosure is being submitted to the parties, the parties, after reviewing the letter, they could jointly and mutually agree to appoint the arbitrator, or they could reject and object the appointment of arbitrator. So if the parties are objecting, stating that the arbitrator has conflict of interest, in that case, they could opt for another arbitrators. And IBA guidelines on conflict of interest, though it is not a mandatory guidelines, but it is a soft principle which is being adopted universally by all the nations. So to check the conflict of interest, the arbitrators should make sure that they do not fall under red, orange list of arbitrators, and green list it is allowed. And jurisdictional examples, as you know, all the countries emphasis regarding this arbitrator's impartiality and independence, though the educational or academic qualification is not a mandatory thing to get appointed as an arbitrator, but his impartiality plays a key role, because if the I think many are joining. So if the arbitrator gets influenced by the activity of one of the party and passes an award, so that kind of arbitration award could be challenged, and it would sometime become, it could sometime become invalidated. That is, the award passed by such arbitrator could be invalidated by the court. Next is ethical guidelines. So let us see what is the rules of arbitral institution speaks on the arbitrators' impartiality and independence. Of course, the institutional rules have their code of conduct for arbitrators, and they emphasize the importance of this impartiality and independence, and often include mechanisms for challenging arbitrators who fail to meet these standards. So let us see what are the challenges, to arbitrator regarding this independence and impartiality. Let me explain this with an example. Suppose an arbitrator previously worked for a law firm that represented one of the parties in the arbitration. Even if the arbitrator was not directly involved in the particular case, their previous association with the firm could create a perception of bias, leading to question about their independence. So it is very much compulsory for the arbitrator to disclose such kind of association with the parties. So after that, it is parties discretion to decide on his appointment. One more example, an arbitrator may have a minor or indirect relationship with one of the parties, such as attending the same industry conferences. While this might not be a significant conflict, failing to disclose it can lead to challenges if it is later discovered by one of the parties. So it is very much crucial to for the arbitrators to do a full disclosure to maintain the trust in the arbitration process. Next is parties' influence. I hope you had come across this institutional and ad hoc arbitration. Let me brief it, brief out the ad hoc and institutional arbitration. Institutional arbitration will be having a panel of arbitrators, and they will be having their own rules. So if the arbitration agreement emphasizes that arbitration could be conducted only through institutions, then of course it will go to institution. Uh, there are numerous institutions across the world, which are ICC, CAAC, and many more institutions. There is another type called as ad hoc arbitration, wherein the parties wherein the parties they can mutually sorry wherein the parties they can mutually agree and decide the arbitrator appointment. So since the parties have direct connection with the arbitrators, there is more possibility of the arbitrator to get influenced by the parties by offering incentives or exerting pressures, etc. In institutional arbitration, they will be having clerical people who will be handling the cases, and the arbitrator mostly they won't be having direct connection with the parties, whereas in ad hoc arbitration the arbitrator will be having direct contact with the party, so there is more possibility in ad hoc arbitration wherein the tribunal may get influenced by the parties offerings. So let me explain this with an example. A party must be subtly pressured by a party. The arbitrator might be pressured by a party that regularly appoints them in other arbitration. So in that situations, it can determine the impartiality of the part if the arbitrator feels compelled to rule in favor of the influential party to secure future appointments. Okay. In all previous slide, we have seen what is independence and impartiality, bias, uh, influence made by the parties to the arbitral tribunal. So, what are the consequence of the tribunal reaching such independence and impartiality? The first consequence will be annulment of award. Whatever the award passed by the arbitral tribunal that is being influenced by either of the party. So, such kind of award, if it is challenged before the court, that award will be invalidated by the court. So, in the case of Reliance Industries Limited versus Union of India, the Indian Supreme Court, which is Apex Court, set aside an arbitration award due to the arbitrator's failure to disclose a conflict of interest highlighting the severe consequences of such breaches. So in this case, the arbitrator, has failed to disclose his past relationship with the parties. So it amounts to a conflict of interest, and hence the Supreme Court has set aside the arbitral award passed by such arbitrator. Next is damages to reputation. Of course, if the award are being invalidated by the court saying that the arbitrator is being influenced and is biased, so obviously, the arbitrator's reputation will be damaged, and if he's been empaneled in institutions, they will definitely blacklist him in future cases. Okay, so arbitrators' impartiality and independence, though it is not a legal requirement, but ethical imperatives to hold the fairness and credibility of the arbitration proceedings is very much required, as you all know. And since the arbitration proceeding continues to grow globally, the importance of maintaining high standard of independence and impartiality will also increase. So technical advantages and evolving global standards may introduce new challenges, but they also offer opportunities to enhance transparency and trust in the process. So uh, since many of the candidates are from technical backgrounds, please make sure that if you are being appointed as arbitrator, if you have any past, if you had or have any past relationship or current relationship with either of the parties, you make sure that you disclose it before the appointment. So it is the party's discretion to either appoint you or to reject. So that does not stop us from the future opportunities.